We ready? Okay, you tell me. Are we on?
You're on.
All right. We're on the record at case number 4:17 CR 3038. This is United States of America versus Michael Wayne Parsons. Counsel for the government, please enter your appearance.
Good afternoon, Your Honor. Jan Sharp appearing on behalf of the United States.
All right. And sir? Mr. Parsons?
I'm Ambassador Michael Parsons. I am here by special appearance only, under duress, by force, against my will. I should let you know, Judge, that I've not been given any notice of this hearing today, so I'm not sure what I'm here for. I'd reviewed the rules of court that you had referenced, and I'm supposed to have been given advance notice of all hearings. I was moved from Saline County Jail on the Tuesday a week ago down to Leavenworth, and then moved up to Douglas County Jail yesterday, and consequently, my property, all of the legal material that I had that I loaded in front of officers at Leavenworth, loaded onto the van in Leavenworth, unloaded, and put into the U.S. Marshal's hands. When I was released from their facility, I loaded it back onto their van and then loaded it into the delivery place at Douglas. But immediately, within moments, where they handed it to me on the other side of the counter, I opened it up to go through it to get what they said I could get. And I noticed that in my Black's Law Dictionary that I had tabbed, I had evidence, photographs, very crucial to this case, not there. I asked the tall gentleman who had the property if he had gone through it. He said he searched it, but said he didn't take anything. Somebody has taken my photographs that is evidence for this case, as well as all of my notes that I had, and there was envelopes that had legal material pertinent to my other cases that's also missing. I've been separated from my legal material. If you've mailed me anything, I haven't. The last thing I got was filing number 61, and I responded to that. And I understand that this gentleman behind me.
It's okay. Don Shenzi.
Shenzi?
Shenzi. That's how it's pronounced.
I apologize.
No,
I knew him as Don.
Don will work. I'll understand what you're talking about.
He said he would try to assist with this, but basically I'm not sure why I'm here, and I don't have any notice of anything since that rule, that filing 61.
Okay. How about if I catch you up a little bit? Because I think the mail is not keeping caught up with you, since we have to do everything by mail. The court became aware that you'd been moved to Leavenworth. I know that a part of that was because they wanted to make sure that you had more access to a law library. It also became one of those things where I was concerned that I had left it with you that if you wanted an attorney, you needed to let me know, and I was concerned that your trial was approaching quickly, and that with all of the transfer stuff going on, that I may not get that notice in time for you to be ready. And so Mr. Shenzi graciously agreed to meet with you, and so we moved you up to Douglas County, and he has, I believe, met with you. My question of you, sir, is it is difficult, no question about it. It is difficult to represent yourself in federal court, and my question of you right now is, after having an opportunity to talk with Mr. Shenzi, and knowing that I'll appoint him to represent you at no cost to you, are you willing to have him be your attorney in this case?
It is true that I was, from the time that I was moved, I've had no access to a law library in Leavenworth. I was down there for a week. No access provided at Douglas. I've asked repeatedly and explained to them the deadline, and that I've got a thumb drive that I've still got about 40 hours of audio to listen to. And one of the notices I sent to the court was that on the thumb drive there are actually 6 files for video that have different references of different people, but the same videos on all 6 of those files. There's no different video. So I'm thinking that either inadvertently a single video was improperly copied to those 6 files when there ought to have been videos of other people that the file names reference, perhaps. And perhaps Mr. Sharp may be able to respond to that if there are actual other videos or if it's just a single video where it's recorded 6 different times on the same thumb drive. I did get to speak to Don. I did not get to question him per se about his knowledge of certain issues. We spoke for about 50 minutes yesterday where I explained to him what has culminated to bring me here as much as possible in the time that he was available, but I didn't get a chance to speak to him about his position, background per se, on knowledge of things, and there's more questions I have for him. And because of the fact I wasn't aware of this hearing until yesterday, I still haven't been served notice of it. I would request, if possible, a couple of days, perhaps come back and be aware of what's I'm going before now, and then having had an opportunity, maybe if it's in Mr. Don's schedule, to allow additional time to speak to him to answer these questions, perhaps, then I can answer the question that you have.
Okay. Your choices are at this point in time to represent yourself or to have Mr. Shensi represent you. Mr. Shensi, can I ask you to lean up against the microphone here? I'd like you to explain to him your background and experience.
We've covered that, Your Honor, as far as...
Okay, so what questions do you have about his credentials, not about your facts of your case, but his credentials, before you can make your decision?
Although I could, in general terms, answer that question, there are some things that I would like to ask him without being in the purview of the U.S. Attorney for the confidentiality. And the fact that I've not had access to make a phone call to the hereditary Grand Chief, Stanley Stump Sr., and have not been able to contact others who could reach him over this past week and a half now, that creates an issue because as an ambassador of another nation, I have to have the authority from the hereditary Grand Chief before I can do anything like this, because there is a jurisdictional question that has never been addressed by the petitions that I've filed. I've got 3 petitions before the court that have never been responded to, and I don't know if the petitions were received because I don't get a response back from the clerk acknowledging the receipt. All I can do is put it in an envelope and give it to the guards, and if they mail it, great. If they don't, then I don't know about that. I don't get an updated version. I don't have access to an updated version of that listing of things. I don't know if it's called the docket, but the listing of numbered items. I don't get that, so I don't know what's been filed. I understand Don said there was 80-something things there now. The last I heard, there was
some of that stuff has just been filed today because your trial is coming up so close. Okay, here's my thoughts. Under the circumstances presented, particularly where you're having difficulty getting through all of the evidence, and I believe the government may even have more, where you've had difficulty getting through all of the evidence, where you've gone through this process thus far without an attorney, it doesn't feel like justice to me to have your trial scheduled for only 2 weeks away. It feels, and sometimes it feels to me that, or I believe that you need more time. I also believe that you need to have an attorney on this matter, and I know that you also have an equal right to self-representation But for right now, I am going to appoint Mr. Shensi to represent you. If after you have talked to him, you want to represent yourself, you may let me know. But for right now, I'm going to have him represent you. Primarily because I'm not getting a clear sense of which way you want to go, and I'd rather go in favor of having you represented and let you choose at some point to specifically state that you are wanting to represent yourself than the path I've been trying, which is have you tell me when you want an attorney. That, and I do believe that you and Mr. Shensi, once you've had more of a chance to talk, will have a very good client-attorney relationship, and I truly believe in his skills to be able to represent you adequately. But I also truly believe that we have to move this trial some down the road so that some of these paper filings that are being filed are things that you can talk with him about and decide how to respond to before this case goes to trial. That would be my thoughts. I'd like to hear your thoughts, sir.
Well, I realize that I'm an innocent man sitting here before a tribunal that I'm not familiar with, that I'm basically kept in a cage. I've been locked up now for over a year for something that I'm not guilty of, and I know that the U.S. Attorney's Office controls where I'm at. They control the U.S. Marshal's actions. The fact that no one has ever asked my health conditions, is it contraindicated to force me to do a TB vaccine which has known carcinogenics, or is it contraindicated to force me to do an x-ray since I have a prohibition from a doctor because of my status as a manager with FedEx? Like a piece of toast, if you x-ray yourself, a toast in a toaster oven, the bread turns brown. You can pull it out of the toaster, it never gets any lighter. That's cumulative. That's how radiation is. I've been advised don't do a dental x-ray. No more radiation because of the exposure that I had when I was a manager at Federal Express. It's documented at Federal Express. I've been advised since I was in the 3rd grade, do not take any vaccines because you're hypersensitive to chemicals. I do my research. I know that the TB test can be determined based on a breathalyzer and a urine test. Non-invasive. I don't mind that. And there's actually facilities in this state that do that. It's not expensive. If the reason the U.S. Marshal Service is curious about TB is legitimate, they shouldn't care about the procedure that it's determined. They should only care about the outcome. For some reason, they want to stick a needle in my arm or give me radiation that's harmful to my health, which is what I'm trying to avoid, is harm to my health. I've probably aged 10 years in the last year with loss of hair and stress and malnutrition and being attacked physically. And not to mention the abuses that's been fostered upon my family by a corrupt FBI and others who are trying to abuse me because of a backwards mafia Tipton County government that's run amok. And had it not been for that government contacting the FBI, I wouldn't be here today. And consequently, whatever they claim they found wouldn't have been there, because I believe that that's something that they had in their possession all along, waiting for an opportune moment to plant. How can you find something 2.5 months later when a plane's been open and accessible in a community hangar with video provided? I don't know if you've seen it. Doors wide open, and the operator of the airport says, well, I've been here every day checking the battery behind the seat, right where the photograph is of where they claim they found a rifle. I know this is not the right time to present this, but mine is a case where I'm being abused by a system I don't understand because I read the rules and it says I'm supposed to get notice for these hearings. I don't get notice. I file petitions with the court. I don't get a response. I send letters to the clerk asking for copies of stuff back, but I don't know if the clerk's getting them because I'm held in a cage. Every time I've been asked to show up in court in Tipton County, I've shown up in court. The time that I was not ordered to show up for court, I didn't show up because I didn't have an order. I've complied with the law every time I've been asked to comply with the law. I'm not a danger to anyone. I've asked Memphis to respond to me with the court. All those listings that you had when you denied me bond, they're all dismissed. I asked Tipton County to respond also because the one charge of an aggravated assault or assault and battery came back a not true bill. The grand jury said it didn't happen because it didn't happen. It was a false charge. And in 6 different occasions, the charge of unlawful possession of a weapon, it's the same charge. It's from the same case that they've dismissed, I know of twice since 2014. The FBI claims, well, because he doesn't recognize the court's authority, they can't go forward. If they had authority or if they had a case, they would go forward. In that case, the fact is that I wasn't even there. They confiscated my wife's guns that were locked up in her house, and the matter's been dismissed because they found out we're going to have a hard time getting conviction when he wasn't even there. I would like to be able to address this court properly. I would like the freedom to be able to speak on the phone. I've been denied access to a phone now for several weeks with the government of the Chilcotin Indian Nation, Stanley Stump Sr., the hereditary Grand Chief. I think if I can present to the court that I'm not a flight risk, that I'm not a danger to the community, that there's no one that fears me except the district attorney in Tipton County who I sued, and the chief deputy who was a former FBI agent who's the one that called the FBI and said he's a sovereign citizen, he's a terrorist. But if I could show Your Honor the jail's own booking sheet, it says nonviolent, not escape risk, and his career path, his occupation is ministry. These would demonstrate to the court perhaps maybe granting this innocent man an opportunity to prepare. He could present to the court and perhaps to the U.S. Attorney's Office evidence that he might not be aware, that he might be like Mr. Zapluski saying that I had a computer and thumb drive in my cell. That's a lie. The video of me, I'm in there 24 hours a day. I've never had a computer in my cell with a thumb drive. I didn't flush it. I didn't do anything to it. I don't know what happened to it. But I'm being accused of things to prevent me from accessing discovery, access to the court, and the right to know what I'm dealing with. That's, I think, in the realm of fairness expected in a legitimate court, to let a man know what he's facing and what rules apply, and is he even required to be here? Does the court have jurisdiction? Does the fact that he is recognized as an ambassador? I was told, I got a letter. I was told that somebody in Rex Tillerson's office actually recognizes me, and they sent a letter. I haven't gotten that letter, but I just found out yesterday that 2 days ago, Rex Tillerson's no longer there. So I'm batting 1,000.
Okay, so here is what we're going to do, sir, because I'm recognizing what you're saying. I'm hearing what you're saying. I've seen your motions indicate you're having trouble reviewing discovery. I don't doubt that.
Your Honor, I'm sorry. I apologize. I cannot hear you.
Oh, I'm sorry. I'm the one who should be sorry. I wasn't speaking as much into the microphone as I should have been.
Thank you.
I'm hearing what you're saying. I'm hearing your concerns. The court's concern is to make sure that whatever trial occurs in this case is a just trial and a fair trial. Under the information that has been presented to me, you are continuing to have difficulty reviewing the discovery in the case. I also have found before, based upon your statements in a prior hearing, that you cannot afford your own attorney. For that reason, at this point in time, I am appointing Mr. Shensi to represent you as counsel in this case. He will be your attorney in this case unless at some point in time you choose to represent yourself and make that statement very clear to me. Understand, I recognize you have the right to represent yourself if you want to represent yourself. But where an ambiguity exists, and that occurs and is occurring in this case, I believe that the best course at this point is to have an attorney represent you until such time as you tell me otherwise. Mr. Shensi, are you going to need additional time to get ready for this trial?
Yes, Your Honor. May I move up to the
Absolutely.
table and
Please do. Thank you.
Thank you. May I enter my appearance?
Yes, you may.
Don Shensi on behalf of Mr. Michael W. Parsons, who is seated next to me.
All right.
And could we address those issues about time?
Yeah. Again, the primary focus is getting to the truth. So whatever you need on that regard, you let me know.
Would you like me to stand or remain seated?
Please stay seated.
Judge,
that standing stuff is an Omaha thing.
Habit for me, I'm sorry.
That's okay.
As it relates to my schedule, I have a very busy trial schedule. I just got done doing a 2-week jury trial here in federal court in Omaha, and I have a number of state court trials coming up in the spring. I believe most, if not all of them, will go. A couple of criminals and a dental malpractice to throw in for good measure. And then I've got a couple of briefs due also. So by having said that, I know that I would hope Mr. Sharp might provide me a clean copy of all of the discovery, unless I could get it from Mr. Vanderslice.
I think Mr. Sharp will give you what you need.
Yes, and then taking the time to review it, of course, properly and with my client, I want to make sure that he has access to me and to the discovery and that we can discuss it in its entirety and fully. And then, of course, an enlargement of time then, please, to file pretrial motions. I understand there was a search of an airplane, and obviously that needs to be reviewed and possibly litigated. I don't know for sure, but that might be an issue. And then, of course, a trial date. So to answer your question, Judge, I don't know when Mr. Sharp could get me the discovery, but I think I would need at least 30 days to review it and then file any pretrial motions. And then time, of course, then to hear the motions and try. I don't know if the court would be inclined just to take it that far today or look at any proposal.
How about if we do it this way? How about if we set I'll have Mr. Sharp provide you with copies of all of the discovery in the case within 7 days. My guess is he can get it done even quicker than that in light of the fact that was close to being ready for trial. That he give you all of the discovery within 7 days and that we set a pretrial motion deadline for what is 6 weeks down the road, Marion?
Let's check. That would be about April 30th, Judge.
Would April 30th work as far as a pretrial motion deadline?
I believe so, yes.
And then what we'll do at that point in time is there may well be pretrial motions filed, in which case we won't have to worry about this. But April 30th, Marion, what's the next business day after that?
May 1st.
May 1st? Can you look at my calendar real quick?
I'm on your calendar, Judge. And
Perfect. What do I have available? Okay.
Oh, Judge, that's why it's ad hoc.
That's right. Okay, then we're going to go a little bit further. what I'm trying to do is get it something on the calendar itself so that we're touching base and finding out how things are going before we go down the path of setting it for another trial. Am I in the office on the 8th, 9th?
Judge, you were in the office on the 8th. You have a lot of stuff. You are completely wide open on the 9th.
9th? How about the 9th?
May 9th.
May 9th.
Yes, that's fine.
Okay, let's do May 9th. I'll come here. We'll do a 10 o'clock a.m. hearing. And the purpose of that hearing, and this may be canceled if pretrial motions get filed, in which case I'll be setting it for other hearings anyway.
Yes.
But if pretrial motions are not filed, then we're going to have a May 9th, 10 a.m. hearing to discuss how this case is going to go forward, what kind of trial date everybody wants, those types of things. And we'll just kind of take this one step at a time. All right?
Yes, Judge.
Anything else that I can do for you today?
Could we address the issue of
You can address anything right now. I'm here.
where Mr. Parsons might be? I know Mr. Parsons has indicated to me that he was in Saline County in Wilbur, and then Leavenworth, and now he's in Douglas.
I'm hopeful that the marshals can keep him in where he's at right now.
Good. That would help tremendously for my
Part
access.
of what happened in Saline, sir, was that they just had a crowding issue that was coming up. And the crowding issue wasn't so much with people, but a lot of people needing the same resources, including the library. And so they were struggling with trying to keep everybody accommodated under those circumstances. So they thought they were doing the right thing by sending in Leavenworth, and ultimately now you're here, and I think we're on a path that can lead to a just result. So.
And to the extent, I want to make sure that he also, my client also has access. He tells me he has 3 boxes of discovery, and I don't know if the court can direct the marshal or somebody to help ensure that he has access to that. Mr. Parsons has told me that he's made numerous notes and he's done research and he's got all of his papers, and I think
maybe the best thing to do, Mr. Parsons, at this point in time is I can tell the marshals to make sure that your legal information is available to you, and make sure that you do discuss it with your attorney. Because you've already put a lot of work into this file. He's got some catching up to do, and you'll be helping him do that.
The court should know that my file has been gone through every time I've been moved by at least 3 people out of my presence in the marshal's property. They've gone through the files and mixed things up, and I'm missing evidence. I need assurance that my evidence will not come up missing again. I can't replace these photographs. These are photographs that I had 1 copy of, and that's it.
Was the copy from the government? I mean, was it photographs that you personally took?
No, they were photographs that my wife took, and she cannot replace them. She's been railroaded into a prison. Okay. And yes, an innocent woman, my wife of 33 years, hadn't had a parking ticket in college some 30 years ago, University of Memphis, is railroaded into prison because the FBI framed her and said, if you don't plead guilty, we're going to lock you up and your animals are going to die. We don't have any children. Our farm animals are our children. She was extorted in pleading guilty so that our animals wouldn't die. And now she's sitting in a federal prison for 5 years for a false charge because the FBI's hammer is always looking for a nail. And like Mr. Zapluski, who seems to find it amongst his time to claim that an email he got from the chief captain at Saline claimed that I was in a cell with a computer, is a fabricated fiction from Neverland, because that's not in the email from the captain. And I spoke to the staff there at Saline, and they laughed and said, Mr. Parsons, we don't let people have laptops in their cells. You go into the law library, which is basically an empty room with a table, and you have an officer sitting beside you. And I said, but how could this Mr. Zapluski come up with this? And the U.S. attorney included in a notice in motion in the court, or some directed to the court that I'm somehow destroying this thumb drive, which is the discovery that I need to review to determine what is beneficial to me. And
Judge, I'm going to interrupt my new client. I think we can handle this by if Mr. Parsons has access to his discovery, all of his papers, and if he's missing anything, he and I will talk about it. I'll make a list. I'll talk to Mr. Sharp about it, and we'll see what direction we can go to try to alleviate any of those concerns.
I appreciate that.
The court has indicated how important it is for him to have it. I can help facilitate that.
Perfect. All right.
I'm going to come back
Yes.
down and see you.
Can we get a court order?
Yes.
that they direct
All
the
right.
judge to
And
do?
I assume, Mr. Shensi, that you believe that the time between now and the new trial is needed in the interest of justice?
Yes, I do.
All right. Then I will take care of that in the order as well. Anything else that we need to take up?
From the government?
No, Your Honor. Thank you.
Thank you. We are in recess.
Come down so we can speak again. Thanks,